declarator, such as the one issued by the court, that's the Constitutional Court, cannot amount to a conviction, a previous conviction, or a criminal record as intended in the section. Now that should close it, because we say that it might look like a conviction to the naked eye, but in terms of the law, it is not a previous conviction. So we were provoking the question that was raised in Faki. Now, so it's not a conviction, it's not a previous conviction, or at the very least, there's no answer to, at best, there's no answer to that question. But that mere fact that question it might be hanging in the air. Imagine if someone was convicted in the magistrate court or in the high court, and then you came and say, is it a conviction? Everyone would say, what are you talking about? It's obviously a conviction. Will it feature in the previous conviction? Of course. Will it be in the SAP S69? Of course. But this so-called conviction in a civil court and in motion court and so on cannot be. The next point comes to the mischaracterization of section 167 and 172 of the Constitution. Imagine if you could wake up some of the drafters of the Constitution and you say to them, when you drafted 172, 1A, giving you the power to give declarators, in that you included the power to impose criminal sentences as a court of first instance. They would say, sorry, that's not. 172, how could you, under 172, 1A, impose a criminal sanction? And that is why you must read 172, 1A. And remember, in paragraph 86 of the Khambembe ADCJ judgment, 86, she says, explaining where the power to grant that sentence, she said, by this point it needs no repeating that the only rationale provided to this court for the granting of a punitive sanction was that put forward by the applicant. However, it is right that this court enjoys a wide discretionary powers and that we are enjoined by the Constitution to grant appropriate remedies that are just and equitable. In these circumstances, and for the reason that follow, I'm certified that an order of unsuspended committal is just and equitable. And the footnote is footnote 101. Look what it says. Section 172, 1B of the Constitution empowers this court to make any order that is just and equitable. Well, I'm prepared to say that, to lay my life on this one, that no drafter of the Constitution would have contemplated that 172, 1A or B for that matter, empowers this court to give a criminal sanction as a court of first instance in motion proceedings, in urgent proceedings. Never. So the very exercise that then goes again to the question of the conviction. This is a conviction in terms of 172, 1B by the admission of the majority. Goes back to the original question. Could it have been that the drafters of the 47.1E, when they were drafting that, contemplated that there will be a conviction and a sentence issued in terms of 172, 1B? No. Surely. The next one is section 167, which is also being abused. Section 167 says that the 167.6, national legislation or the rules of the Constitutional Court must allow a person, when it is in the interest of justice and with the leave of the Constitutional Court, A, to bring a matter directly to the Constitutional Court, B, to appeal directly to the Constitutional Court from any other court. So that's the point. So this court was clearly not exercising, because it said it's denying the right of appeal. So it was clearly not exercising the power under section 167(6)(b). But it was exercising the power under 167(6)(a) to bring a matter directly to the Constitutional Court. How could it be that by giving that procedural right, the drafters of the Constitution wanted to take away the fundamental human rights in Section 35? How could it ever be? How could it be? Because this is a procedural convenience, which A, does not contemplate criminal proceedings, but B, certainly does not contemplate itself defeating the Bill of Rights. It can be. So it's not a conviction for that. Thank you. For that reason as well. Sentence. Now, the sentence we say, we use 35.3.0 as a proxy. Whenever I talk about 35.3.0, you must know that I'm talking about all those rights, because all of them were denied in Section 35.3. But Section 35.3.0 brings the matter home easily. Why? Because Section 35.3.0 says you have a right to an appeal. In other words, that right we know attaches to both the sentence and the conviction. And that right must be exercised. Everything I said earlier about conviction applies to it. But that's not the question, of course. The question, we must always come back to the question in this case. When the framers of the Constitution did 47(1)(e), did they contemplate a sentence such that it breaches, limits, denies 35.3.0 rights? And the answer to that must be a resounding no. And that's what Justice Zondi was saying, that this could not have been in the contemplation of the drafters, that there would one day be what Justice Khampepe called an unprecedented and unimitable situation. You know what that means? That means it has never happened and is unlikely to ever happen again. So it was a particular situation influenced by the fact that Mr. Zuma was a head of state and so on. And there's a whole thing about, there's a whole section on that. So that is why it is in that respect that we say this is what, if you look at it crudely, this was nothing but reminiscent of the so-called Sobukwe clause under apartheid. And whether one agrees or doesn't agree with that categorization, the point is only this. Could the framers have contemplated that when they wrote those words, convicted and sentenced in 47(1)(e), it would include some unprecedented, in fact, I'm putting it in milder terms. Sorry. I think it's paragraph 56. No, 56, at page 32, yes. She said, however, I'm alive to the fact that the case before us is so markedly distinct from any matter that has preceded it, that it exceeds the expectations of legal precedent. The result is that, despite my efforts, I have found very little solace in our jurisprudence. In other words, there's nothing like it. The extent and gravity of the contempt in this matter is singularly unprecedented and absolutely inimitable. So I left out those adjectives. Singularly unprecedented and absolutely inimitable. Who can say that the drafters of the Constitution contemplated such a thing? Now, so the sentence is even in a worse position than the conviction, save for the fact that the sentence is in any event a surrogate of the conviction. And that's why we say we really welcomed, without needing to patronize the court, we welcomed the directions from the Deputy Chief Justice on this question of conviction. Because with the greatest respect, it was absurd to say the sentence is not within 47(1)(e), but the conviction is. The section is very clear that those two things go together. 47(1)(e) says, anyone in this section is convicted of an offense and sentenced to more than 12 months imprisonment. And even in the appeal proviso, it says, but no one may be regarded as having been sentenced until an appeal against the conviction or sentence has been determined. So it's clear that the two things go together. It would be absurd for any court to hold that the sentence was not a sentence because of Section 35, but the conviction was a conviction. So we welcomed the directions in that sense. But let me just say the following quickly about the right of appeal. And you'll find this at pages of our submissions on conviction. From page 8, from paragraph 25. This court said, well, in Dali, it says the minimum that it says 3530, the minimum that it envisages and implies is the opportunity for an adequate reappraisal of every case and an informed decision on it. One of the justices, I can't remember, I think it was Justice Mpofu, asked this question as to whether the Section 3530, they said the minimum, the bare minimum it envisaged is a chance for a reappraisal. And then in staying, the following was said, the right is directed at ensuring that there is a reasonable procedure for correcting errors, coming back to Justice Machit's earlier point this morning, for correcting errors that may have occurred at the trial stage. In a substantial number of criminal cases, convictions result in prison sentences. During its term, imprisonment brings the liberty of the individual to a halt. It also impacts on the individual's dignity. Therefore, it cannot be overemphasized that before this happens, there must be procedural checks and balances of such a nature that wrong convictions and inappropriate sentences are reduced to the barest minimum. An appropriate reassessment mechanism is an important cog in this scheme. I think it was Justice Matlanga who said that. And then in staying, it was also said that 25(3)(h), which is the equivalent of the current 35, that every accused shall have the right to a fair trial and so on. So this court has specifically said on many occasions that the right in 3530 is an inherent feature of a sentence. It's not some by-the-way thing. It inheres in the thing called a sentence. So a sentence that is bereft of that right is not a sentence, cannot be a sentence for the purposes of Section 47(1)(e). Even if you were allowed to do the so-called harmonization exercise, that is completely disallowed. Now, so that's the first part of whether the sentence is a sentence for the purposes of 47(1)(3). Then the last point on the merits is the remission point. Now here, you get literally, gymnastics of the first order. They say that they accept, grudgingly I must say, because they didn't accept this for a long time in the electoral court. But they now say, because there's no other way, quite frankly, they accept that Mr. Zuma's sentence was completed on the 11th of August, 2023. Now, if you read that together with the order of the SCA that we discussed earlier, which said he must return to escort for the purposes of serving the remainder. What was that remainder? The 9 months. So, but for the remission, he would have served the 9 months. I don't know if he would be out now. Maybe not. But you can't wish away the remission, because but for the remission, he would have served the 9 months. And that 9 months, justices, is what is the extent to which the sentence was reduced. Smith says so, Busheko says so, all the cases say so. They say that the effect of remission is the reduction of the sentence. And I don't want to disappoint Justice Matopo, but I'm not in a biblical mood today. So forget about the biblical definition of the remission of sins, which, by the way, is the only reason we all go to church on Sunday. If you thought you could go to church and then when you go there, they say, no, but remember 10 years ago, but you said, but that sin was remitted. They said, no. Mr. Ngcukaitobi says no. So you must go to hell, literally. No. So let's forget about that for a minute and look at the definitions that are more conventional. Sorry. The definition in, I had this. The definition in the Oxford dictionary, law dictionary, says that remission is the cancellation of a part of the sentence. It's that simple.
Section 47 should apply. It is contempt of court. Because it's a crime against the state, it's a crime against the administration of justice, it is a crime against the rule of law, it is a crime against the Constitution. And the primary duty of MPs is to uphold the rule of law. So their intentional defiance of court orders is inimical to that purpose. So in this debate about whether or not contempt of court should be within or outside Section 47, there is a very strong normative case that it should be within the ambit of Section 47. And we see this court in paragraph 87 of the contempt ruling, where it makes the point clear. It is almost crying for help when it says, if the impression were to be created that court orders are not binding or can be flouted with impunity, the future of the judiciary and the future of the rule of law would indeed be bleak. So if we rewarded people that are guilty of contempt of court with seats in parliament, imagine what would happen to the future of the rule of law. The third point is around this double punishment theory. There is no double punishment. This is not a punishment. It is akin to the reasons for the striking of a lawyer or an attorney or an advocate from office. The reasons have nothing to do with expressing a moral opprobrium in relation to what they did to their clients, whether they stole money or not. The reason is to protect the public. Particularly where at the time of the striking off, they still display no signs of any reformative character. So the same object is achieved by Section 47. It is not a punishment against Mr. Zuma. It is simply to protect the public and the institutional integrity of Parliament. Number 4, there is the issue of ripeness. Let me spend a little bit of time on this. The powers of the Commission have been much discussed. It is Section 30 of the Electoral Act that applies. Section 30, subsection 1A, says that any person, including the Chief Electoral Officer, may object to the nomination of a candidate on the following grounds. 1, the candidate is not qualified to stand in the election. Now, that phrase, not qualified, tracks back to Section 47 itself, because Section 47E, the last sentence, says a disqualification under this paragraph ends 5 years after the sentence has been completed. So it's a disqualification provision. But It is put into operation by Section 27, subsection 2, subsection A, which says that if you want to contest an election, you must submit a list. That list must contain an undertaking signed by a duly authorized representative of the party, and it goes on and on. That undertaking is contained in page 147 of the record. So you will see it, page 147 of the record. That is what that undertaking is. It's Appendix 2. This is what it says. Justice Gamble, you raised this point, but never really went to the actual annexure. But this is where it is, at page 147. This is what you undertake. I declare, under 8, I declare that I have confirmed that each candidate on the list is qualified to stand for election in terms of Section 47 and or Section 106 of the Constitution. Section 47 applies to the National Assembly. Section 106 applies to the provincial legislature. So this is all a pre-screening process prior to anyone being nominated for the National Assembly. So plainly, it's an obligation of the Electoral Commission that it must screen candidates for qualification under Section 47 of the Constitution. We have made further submissions in our heads of argument in which we point out that there is a fundamental conflict in what is being submitted on behalf of MK, because they say that you qualify, you are eligible to stand for an office that you cannot hold. And they say, well, the solution is Rule 13 of the rules. When they have to explicate what Rule 13 is about, what they say is that in the first meeting of the newly elected National Assembly, the first order of business is the election of the Speaker. But the question is, who is electing the Speaker? In order for you to elect the Speaker, you must be eligible to be in the Assembly. So they are not answering the question, they're begging the question. So there is a straightforward answer and not the contortions being suggested by MK. Number 5 is the question of bias. Now, there are 2 documents. The first document is at page 272 and 273. That's the document that quotes Ms. Janet Love. And the actual quotation is at page 273. And it is, no, this one is mine, yeah. So this one says that, she says, that excludes anybody who has been given a sentence that was not the subject of any deferral. And in that sense, it is not ourselves, but the laws of the country that would stand as an impediment for that candidacy. So it's a neutral statement that doesn't really take matters anywhere. Then what happens is that when the matter came before this court, new evidence was then introduced, which is at page 493. It now appears that the fulcrum of the bias case is on the new evidence. So page 493 and 494 was not before the Electoral Commission. It's new evidence introduced in this court. And it's introduced without an application for the introduction of new evidence. So it's impermissible. It's pro non scripto. It should not be taken into account at all. So the only issue that was before the Electoral Court is page 272 and 273. And as I say, it's a neutral statement that takes matters nowhere. And the Electoral Court, at least on this score, cannot be criticized. And you will disregard entirely the supposed references to page 493. We didn't respond to it.
Mr. Ngcukaitobi, sorry to interrupt you. Didn't the applicant, in terms of an additional affidavit by Ms. Love, and I forgot to ask you about this earlier, also introduce a new affidavit? And my question is, this is an appeal.
Yes.
Shouldn't it be decided on the basis of what was before the Electoral Court?
Indeed. We agree entirely with that. You can disregard the confirmatory affidavit of Ms. Love, and you will be left with one document, which is page 272 to 273. We agree fully. I'm out of time, Justice, Deputy Chief Justice. I have only one more point, so if I could ask for a minute. Thank you. It is in relation to the case of Disanaike. We listened carefully to what is being suggested. It's actually not correct. The correct finding is at paragraph 8.5 of that judgment. What it finds, what the actual committee found, it did not find that the principle of excluding candidates who have a criminal record is necessarily unfair. It found that the period of exclusion in that case, which was 7 years, was disproportionate. So it was decided on the principle of disproportionality. So you will see this where it says, given that these restrictions rely on the author's conviction and sentence, which the committee has found to be arbitrary in violation of Article 9, Paragraph 1, as well as the fact that the state party has failed to adduce any justification about the reasonableness and or proportionality of these restrictions, the committee concludes that the prohibition on the author's right to be elected or to vote for a period of 7 years after conviction and completion of the sentence are unreasonable and thus amount to a violation of Article 25B of the Covenant. So it was on the disproportionality of the period of disqualification. I have already made submissions in relation to what the remission means and what the appeal proviso means. There is no point in repeating those. Deputy Chief Justice, I want to thank the court for the patience, and we have no more submissions to make.
Thank you very much, Mr. Ngcukaitobi.
Sorry, Mr. Chair, I promise you I'm not exercising my right. I would have normally had a right to reply on the cross appeal, but I'm not exercising that. Just wanted to make a reference that I had promised to Justice Bilkis. It's at page 223, where I was talking about the issue of the heading special remission of sentence for certain categories. So that's what I was saying, it's not a general, of sentence offenders, correctional supervision, paralease. And then there's the list of 13. And in that list, it says sexual offenders, murderers, attempted murder, crimes, criminal lifers, child abuse, and so on. And they don't include contempt of court.